Hello everyone and welcome to This Explainer. Today, we are breaking down an absolutely massive update for the Indian legal community. On August 21, 2026, the Supreme Court of India delivered a landmark judgment that significantly modifies the mandatory 3-year practice rule for aspiring judges. If you're in the legal field, you know that for months now, law students and graduates have been feeling some serious legal whiplash over the constantly shifting landscape of judicial service requirements. Well, today, we're going to clear up all that confusion by looking directly at the court's ruling and what it actually means for your career. So put yourself in the shoes of a law student or a recent graduate for a second. You've probably asked yourself, how do I actually enter the judicial service right out of law school? Can I just take an exam, or do I need years of gritty experience first? Over the last few years, the answers to those questions have bounced back and forth like a ping-pong ball, causing, quite frankly, a ton of anxiety for young graduates who are just trying to plan out their futures.
Okay, let's dive into this by outlining our roadmap for today. We'll be covering 1. The 30-year legal seesaw. 2. Why revisit the rule. 3. Phase 1 transitional scheme. 4. Phase 2 permanent rules. 5. The dissenting view. And finally, 6. What happens next?
Section 1. The 30-year legal seesaw. To truly understand today's ruling, we first need to look at the historical background and the changing philosophy around judicial service eligibility.
You see, the rules for becoming a civil judge have been on a bit of a seesaw for the last 3 decades. Back in 1993, the Supreme Court mandated 3 years of bar practice, stating that experience is absolutely vital at the level where adjudication begins. But then, in 2002, they literally hit the undo button and abolished the rule completely. The court decided that intensive training could basically replace practice, and that a strict 3-year rule was actually turning away top academic talent. Fast forward to May 2025, and the court abruptly restored the 3-year requirement. Why? Well, because high courts across the country were reporting that fresh graduates straight out of college severely lacked court decorum, etiquette, and the practical temperament needed to handle high-stakes courtroom environments.
Section 2. Why revisit the rule? Let's examine the hardships that sparked this new August 2026 judgment and why the court decided to walk back that strict 2025 rule so incredibly fast.
What's really fascinating here is how the court zoomed in on the very human elements of this rule. First off, there was immense retrospective hardship. Imagine spending years preparing for the exam based on the old rules, only to have the rug pulled right out from under you just as you graduated. Second, economic barriers. We all know junior advocates often earn very little, if anything at all, making a mandatory 3-year wait financially impossible for candidates from marginalized backgrounds. Third, there was a disproportionate impact on women. The rule delayed judicial entry to around age 29, which often clashes with societal pressures to marry and manage households, effectively compressing their entire career window. And finally, under the 2025 rules, a candidate might not reach the district judge level until age 41, which really stifles career progression.
Section 3, Phase 1, the Transitional Scheme. Here is the immediate relief provided by the court for current law graduates.
Let's contrast the two approaches. The strict 2025 rule demanded 3 actual years of bar practice before you could even sit for the exam. But under the new transitional scheme, which, keep in mind, applies to all recruitment notifications issued up to March 31st, 2027, all law graduates can apply with 0 actual practice. That's right, 0. The court is legally deeming these candidates to have completed 1 year of active practice automatically. No practice certificate is required to apply.
But hold on, there is a catch, and it's a pretty big one. If you get selected under this transitional window without any prior practice, you do not become a full judge immediately. Instead, you get a brand new designation, Trainee Judicial Officer. While in this role, you undergo an intensive 2-year training period, and during this time, you will receive only half the regular salary of a judicial magistrate first class. So yeah, it's a significant financial and professional reality you have to consider.
Essentially, this is a rigorous 2-year boot camp that trainees must successfully survive before they can independently preside over a court. Step 1 is a full year of intensive training at a state judicial academy. Step 2 is a structured 6-month law clerkship under a principal district or sessions judge. And finally, Step 3 is another 6-month clerkship, but this time under a sitting high court judge. Only after this high court judge submits a satisfactory evaluation report does the trainee finally become a regular judge with full pay.
Section 4, Phase 2, Permanent Rules. Let's look at the post-April 27 regime
because this transitional window certainly won't stay open forever.
Starting from April 1st, 2027, the rules shift permanently. From this date onward, every single candidate must have a verified certificate proving at least 1 year of actual practice in the district courts before they can even apply. And here's the kicker. Even with that 1 year of actual practice under your belt, selected candidates must still undergo the exact same 2-year training and clerkship program we just talked about. So it's 1 year of actual practice plus 2 years of mandatory post-selection training, which effectively fulfills the spirit of a 3-year experience requirement.
Section 5, the dissenting view. We should impartially look at the other side of the bench now, because not all the justices agreed with this new scheme.
Justice Kevanochandran firmly disagreed with modifying the strict 3-year rule that was established in 2025. In his view, the courtroom is literally the most profound of all classrooms. He argued that true legal practice, feeling the actual pulse of litigation, observing how trials are conducted in real time, and interacting with senior lawyers is an indispensable foundation for anyone who is going to decide the fates and liberties of everyday citizens. He basically didn't believe that clerkships and academies could ever truly replace the gritty reality of the bar.
Furthermore, Justice Chandran highlighted a very practical concern. He noted that placing bright young recruits on half pay for 2 whole years could be highly prejudicial and might actually deter top academic talent from joining the judiciary altogether. He also made the point that taking these recruits out of action for 2 years of training would strain the state exchequer and leave trial courts undermanned, as vacancies would just multiply without active judges to fill them.
Section 6, what happens next? Let's map out the future landscape of the Indian judicial system under this majority ruling.
So here's your exact roadmap and summary of the dates you need to know for your career planning. If your recruitment notification is issued before March 31st, 2027, you need 0 years of practice, but you face 2 years of half-pay training. If it's issued on or after April 1st, 2027, you must have 1 year of actual verified bar practice, followed by those exact same 2 years of post-selection training.
But, the Supreme Court isn't just setting this in stone and walking away. The majority specifically stated that judicial recruitment is an evolving process. Therefore, this entire scheme will remain in force for exactly 5 years. After that period, the court will review empirical data to evaluate the quality of recruitment and the actual on-the-ground performance of these trainee judges. If the data shows that this hybrid training model isn't working as well as the traditional 3-year bar practice rule, well, the court has left the door wide open to revisit and change the scheme all over again.
Which brings us to the ultimate question at the absolute heart of this judgment. Is a structured system of 1 year of practice plus 2 years of intensive institutional training actually better for creating a competent judge than simply spending 3 years fighting it out at the bar? It's a massive, game-changing shift in how India prepares its judicial officers. So what do you think about this new trainee system and the half-pay rule? Let us know your thoughts in the comments below. And don't forget to engage with this explainer if you want to keep tracking how this landmark scheme unfolds. Thanks so much for learning with us today.